Well, hello, everyone. I know we still have some folks signing on, but it's a little afternoon. We've got a lot to cover, and so we wanted to jump right into this webinar. My name is Mark Waletsky. I'm a partner in the Labor and Employment Group at Holland & Hart, and we have a few other folks with me today who are going to be presenting. Brenda Berg is a partner and head of our tax and benefits group at Holland & Hart, and she's the person who I go to when I have difficult 409A or ERISA benefit questions, so happy to have her participating with us today. Deborah Hake, our colleague in the Denver office in our Labor and Employment Group, has just been a fantastic addition to our group earlier this year and knows the issues with these new Colorado employment laws inside and out. And we also have Greg Klauser, who he is going to be our important in-house counsel voice on the panel. And he's also an officer with the ACC. He has helped us really put these together, and we look forward to having his insights and perspective as in-house counsel as we talk about how to comply with Colorado's new employment laws. And a couple of just basic announcements before we launch into the substance. Number one, this has been approved for CLE credit in Colorado. I understand the information that you need to apply for CLE credit will be sent out in a follow-up email. We typically send out the materials and that CLE information after the seminar. Number two, we really appreciate it when we get questions throughout. We aren't always able to answer all of your questions, but we will absolutely do our best. So you're all muted because we have right now 80 folks, and so we can't have folks talking, but there is a Q&A function where you can submit a question or use the chat function, and we will, like I said, do our best to answer your questions as they come up. So please feel free to hit us with your questions. We know that these are not easy issues that you're all dealing with right now. And this is the first in a series of webinars. We did earlier this year a kind of, I'd say, more surface level approach to the various new Colorado employment laws that are going into effect starting January 1 of 2021. And we thought it would be helpful to really dive into the details. And this particular webinar is really focused on kind of the first portion of the life cycle of employment, and that's how we're trying to address these new employment laws, because we figure that's how you might be addressing these, is how are they going to impact you in the life cycle of employment. And so this is really focused on what you need to be aware of, the new changes that you need to be aware of when you're really about to hire or hiring an employee. And so we're going to be primarily focused on Colorado's new pay transparency laws that impacts us most of all when we're talking about that aspect. And Luke, if you could forward to the agenda. There's our disclaimer, of course. Let me ask you, Luke, also before I go through these 4 points quickly, could you put up the first polling question for folks to see? So for everyone, we have a few polling questions here throughout, and just want to get an idea of how some of this may impact you. And one of the questions that really may impact a lot of what we're going to talk about initially is really whether you have remote employees or employees working in multiple states. And that's really when we're talking about remote employees. Do you have folks outside of Colorado? Because that really raises a number of issues. So go ahead and check A for yes, B for no, and then we'll have Luke put up the results in a minute or two after you've had a chance to look at that. But as the agenda shows, we're going to talk about posting for positions and pay equity, and unfortunately, those issues are going to be fairly different going forward, and want to make sure everyone is aware of that and find out how folks are dealing with that. We're also going to talk about changes that you need to be aware of with respect to interviews, and specifically talking about wage history with applicants. We're going to talk a little bit about pay audits and how to deal with pay disparities. With the new pay transparency law, that is definitely a big issue. And then we're also going to talk a little bit about employment agreements, offer letters, really just a bit of a refresher in light of these rules, as well as some very important reminders from Brenda on 409A implications. So Luke, I don't know if we have enough responses yet, or if we can put up the results for the poll question. Yeah, so this is I think what we all thought is that most of you do have employees working remotely or in other states, and that's what we see as well, is that most companies now have multi-state operations, and we'll definitely talk about how these new rules impact you as well as folks who are only in Colorado. So with that, let's go ahead and jump in. Can we advance the slide? So with respect to the postings, what we thought would be helpful is really just to kind of walk through a sample posting and highlight some issues that you might see. And obviously, this is just kind of a made-up posting, but you'll see it's got the job title, the location, and the job description. And why don't we go ahead and advance to the next slide and start talking about the issues. So one of the threshold issues that you really have to ask now with the new pay transparency law is this a promotional opportunity? Because as we've covered before, and I think as probably most or all of you know, under Colorado's new pay transparency law, if you do have a promotional opportunity for employees, you have an obligation to post that for all of your employees to see. And all means all. Whether they're qualified or not, they get a chance to see that promotional opportunity. So, the question is, well, what is it? How do we know if this is a promotional opportunity or not for our folks? And the final rules issued by the Colorado Division of Labor and Employment do provide some help. They do define a promotional opportunity, and they do define it with certain terms, including it's got to be a vacancy for a new or existing position that could be considered a promotion. And what that really means is look, it could be a possible advancement for someone, or it could help someone advance their career. It's not limited to someone just going up in pay. It could be, that could be it, but it's not that limited. So it is a little bit broader than you might think. And so, you know, these are questions that, all questions that I think ought to be asked now before someone is, well, number one, before you even do a posting is, hey, is this something that we have to inform our current employees about? Is it a promotional opportunity? And if it is, they need to see it before a candidate is selected. And you need to ensure that people actually do see it. It's got to be communicated to them in a way that's, and you know, make sure they see it. So, for example, if you've got an office right now, let's say where everyone's working remotely, and someone goes in and posts a job posting in the break room. That, to me, is probably not a great idea right now. I think that's probably not going to meet the intent or letter of the law, but it is. So you'll have to look at that. And I did see it. There was actually just a question: if someone's promoted from engineer 1 to engineer 2, do we have to post it? That's like the $64,000 question. Greg and I were just exchanging emails and talking about that, and we will definitely get to that question. I promise you, we're not ignoring it. But this is a bit of a brave new world where I think some additional steps need to be taken before posting. And Greg, I don't know if you have anything to add here about, from an in-house perspective, how are you dealing with that for example, your recruiting department and making sure they're kind of looking at these questions before a posting goes out?
Yeah, well, this is a brave new world, right? And it's required significant change management within our HR department and then beyond to the business units. And this is really tricky for in-house counsel because our internal clients come to us expecting that we have the answers. And this is one of those situations where, you know, often we have to sort of make things up on the gray areas, but here there's a lot of gray. And that is what is creating some difficulties with the transition. It's hard for me, and I found it's hard to go to my internal clients and tell them that there's something coming down the pike, things that are going to have to change, but I can't provide them any clear guardrails on what, for example, is a promotional opportunity. And so we have nevertheless worked with our talent acquisition teams, with our HR BPs, with our business leaders, at least our key business leaders, to let them know that this is out there, even if all the details are not yet finalized. We've prepared them so they know that there will be changes, and the changes will be for the worse from their perspective, right? More restrictive in terms of how they can do things. Before, it was the Wild West, frankly, and I know it is at a lot of other companies where HR and managers sometimes will, on the fly, make a promotional decision without any posting, and that's clear that's going to have to change. It's unclear how much that's going to have to change, but I've already prepared them that it is changing and they need to sit tight and buckle up. And ultimately, we're going to wait to see. I think there may be some new guidance coming out, I think, in the next week or two from the agency that might help us understand this a little bit better. At some point, we are going to have to sort of feel our way through the dark, come up with what we think is the right thing to do, compromising perhaps a little bit what the black letter law says, was also what our business processes require us to do or the business needs us to do. So whether it's soup to nuts, we've started with the talent acquisition team, telling them what they can and can't do, what's changed, and armed them to handle questions that we anticipate receiving both from candidates, from internal incumbents, especially, you know, I know we'll get to this about job postings or salary ranges, and also to help them prepare the hiring managers for questions. And we'll cover some of those more specific details as we go through the slides, but this is difficult, and it's difficult when we don't have clear answers. it's where we are, and so we're going to make the best of it, and with making some course corrections, hopefully over the next several months.
Thanks, Greg. That's helpful. I agree with all of that. One question came in over the chat about, does this apply to employers of all sizes? And the answer is yes. There is unfortunately no small employer exemption. I've also I'm getting questions almost daily on these new laws, and probably maybe an even split, but I think more questions are tilting towards the paid transparency over the paid sick leave law. And the questions on the paid sick leave or on the paid transparency law in this posting, some folks have asked, well, how strict do you think this is going to be enforced? And it's a great question. I mean, it really is. And my answer at this point is, I would assume it's going to be strictly enforced right now to the letter of the law, because we don't have any indication that it won't be. So for small employers, for large employers, starting Jan 1, this is the law of the land. You know, it's going to be one of those things that folks will have to grapple with as we get more guidance. As Greg mentioned, I'm hoping that helps. Some of the guidance we've gotten has not been entirely clear. We always appreciate whatever guidance we can get, but we certainly hope we get more guidance. At the end of the day, it may be that the courts have to work some of this out in cases, and what I always tell clients is you don't want to be that court case. Luke, if we can go ahead and advance to the next slide. So this gets to the question of the day, the inline promotions or elevator promotions, as some people say. And what I mean by that is, for example, in this context, you have a data science analyst 2. If you have someone who just moves from data science analyst 2 to data science analyst 3 because they've been with the company for a period of time, because they've demonstrated certain, key deliverables or skills or qualifications, do you have to post that? And this is a really hard question to answer right now, because this is one of those areas where we have some guidance. There is, in my view, a little bit of conflict between the final rules and the division's stated intent with this, because the division has defined a promotional opportunity to mean a vacancy. And if you're doing an inline promotion, are you really filling a vacancy? And let me come back to that in a second, because what I'll say as well is the division has made clear there is no blanket exception for inline promotions other than those that occur automatically within 1 year and it's set forth in an offer letter. I don't know about you, the participants, Greg, others. I don't see that often where there is an automatic inline promotion. It tends to be a little more discretionary than that, but often you're not filling a vacancy. And so while this issue is unsettled for now and absent any further clear guidance from the division or the courts, my own view on this is that if you are looking at promoting someone from a level 1 to 2 or 2 to 3, it's not a vacancy in the traditional sense. It's just, hey, this person has been in this role now for a year, and they have now demonstrated the appropriate milestones in order to move up to a, analyst 2 or 3 or 4 position, whatever it might be. I think there's a good argument for saying that really isn't a promotion in the sense of what's stated in the final rules, because there's no vacancy that you are filling. It is purely focused on that individual person. That's not entirely clear. There is some risk with that, but I think that's different if you are moving someone up from a level 1 to a level 2 or 3 or 4, for example, because you've got a gap at that higher level. Someone else has moved up. You've had a number of people move up. You've had people quit. If you are moving someone up because you've got a gap at that higher level that you need to address, I think that would be considered a vacancy, and I think that would very likely, if not definitely, be considered a promotional opportunity, even though someone might argue it is a quote-unquote inline promotion. So I know that folks are really grappling with this. Greg, you and I obviously were going back and forth. What are your thoughts on this one?
Yeah, it's tricky. And, you know, at the end of the day, I'm trying to advise my internal clients the practical answers on how to frame this. And a couple of things that we've been batting around are maybe analogs or corollaries to the vacancy rule. So questions that we've pondered to help us think about this is there somebody else qualified for this, or is there nobody else qualified? So, for example, if there are 3 people who are equally qualified for this, but you're promoting only one of those 3, that seems pretty risky not to post that position, right? That suggests to me that there is a vacancy. If it's single-threaded, and I'm just going to make something up, let's just say I'm the only attorney with employment expertise at my company, which I'm not, but let's just say I am, and I've been there for 3 or 4 years, and as a reward for my loyalty and good work, they want to promote me from a senior attorney to an attorney to a senior attorney, but I'm the only one in the company, then I think it's less likely that there's a vacancy. That's more like an inline promotion that I would think would not need to have a posting. That's one way we're trying to slice the bologna, and not to say that it's right, but for practically speaking, as my HR colleagues are trying to think about how to do this, this is one of the ways that I've challenged them to think of it, so that we can decide whether or not it's a high-risk situation or a low-risk situation to not post or post. I think the other way we've talked about it is whether there's a backfill. And so there can be different ways there's a backfill opportunity, and maybe backfill is just another way to say vacancy, right? But if I move from attorney 1 or attorney to senior attorney, does the company plan on backfilling my position? If so, that suggests that there's also some sort of vacancy that needs to be accounted for. And so we have to be careful to think about where or when there's a backfill opportunity. Or is my promotion into the position a backfill, as Mark said, to somebody who's left the company for retirement, they won the lottery, something. And if there are people moving around, if you're moving people and I'm going to replace somebody else, that also suggests a vacancy for which there should be a posting. One of the things that I've said, and part of it is me trying to challenge my HR colleagues, is who cares if we post it? Just post the position. Why not just post it? Err on the side of caution and just post it. And so one of the things, Mark, that I think I want your feedback on is why are we fretting so much about this? Why don't we just post things, post them as we would normally? Does that create extra obstacles legally? Or can we just do it as a matter of form, even if it's form over substance in some regards, because we already know who we're going to promote to the position?
Yeah, I think that's a great question, and my only concern from what I've heard from clients is, do they really want the administration associated with posting all inline promotions, where it really is just the one person? There's no vacancy, there's no gap filling, there's no nothing. Do they really want to go through and post it? Because if they post it and now you get a bunch of applicants and the applicants are not appropriately interviewed, considered, or vetted, then are you taking on additional potential liability, creating claims, creating morale issues? I mean, there's a whole host of issues that come along with that. And so on the surface, I totally agree. Overpost. The downside is now once you post, you have to deal with the consequences of posting, which may be you got a whole bunch of people you have to interview and think about. And maybe for some companies, for some positions, you'll look at that and say, you know what, that's the right answer. that's the way we shouldn't be doing inline promotions for these particular positions. And maybe it forces that second look, but I do worry about just saying, let's just post for all of them because of those additional consequences.
Yeah. So let's go back to my hypothetical of, let's say there are 3 attorneys who are all equally qualified, at least initially, and there's 1 senior counsel position. I think one way to help decide whether or not there's a vacancy is making sure the job description for the senior counsel position is written accurately in a way that might self-select or auto-select one of the 3 candidates, right? So a senior counsel position must be with a company for 6 years. Well, if I'm the only one with a company for 6 years and the other 2 have only been with the company for less than that period of time, is that the situation where we don't have to post now because there's only 1 qualified candidate internally? These are the tricky questions that start to, once you start to think about the practical application, HR certainly in that situation doesn't want to post. I am the only one who's apparently qualified based on this rule written in the job post for the senior position, or the job description, excuse me, that has the right tenure for that position. And so their argument is there's only 1 person who's qualified. We shouldn't have to post that. So that's really just an inline promotion or an elevator, right? And the others will get there eventually, but they're just not there yet. And so, in that case, I think, and we certainly have made decisions on this, I think I'm sympathetic to the HR team on that, right? But knowing that there may be some risk to that. So one of the other questions I had for you, Mark, that I think is unclear, at least that I keep getting from my HR colleagues is, does this mean we have to post only internally, or do we have to set up an external post in every instance? Is this going on Indeed and Monster, or is this just something we post internally on an internal internet job board?
Yeah, so that's a great question too. Two different requirements here, and this actually also fits in with the question we got on the chat too. If it's a promotional opportunity, you have to post it internally for your employees. You don't have to post it externally. So there's no obligation for you to post it externally. But if you think about if you're posting something externally, then you're almost certainly going to be posting it internally as well as a promotional opportunity. I'm having a hard time off the top of my head, and I have been having a hard time coming up with situations where you're going to post something externally that could not possibly be a promotional opportunity for anyone internally. It would have to be so different from anything anyone is doing to exempt you from that, to avoid having to post it internally. The external posts, so 2 different issues, they do go together, but anytime anything could be considered a promotional opportunity, you have to post it internally. This is true, and so here's the chat question. Well, what if we had an opening, a requisition that was opened in 2019, but it's not going to be filled, or 2020, I should say, won't be filled until 2021. The new law applies Jan 1, 2021. And so my concern would be if you are in process, but you haven't made a final decision, you ought to comply. I haven't had a chance to give that a ton of thought, so that's my off-the-cuff reaction, but I'd be pretty concerned about saying, well, we started the process earlier, and so we were exempt, because I'm not aware of that exemption. I think on Jan 1, if the position is open, I would comply with it. And for another question we received, if you don't have an intranet, send it out via email. I mean, post it in a way that is reasonably accessible to folks, because not everyone does have an intranet. And for some folks, I was saying, well, what about the folks who are working remotely? There are some jobs where they're essential workers, they don't have emails. They're not on a computer. For them, sending something out via email may not be the best way because they're in a manufacturing environment or something like that. So, I think all of this is it's more gray than what I would like. Let's put it that way. But I think at the end of the day, if you're looking at these and saying, you know, we're filling an open role here. This isn't just, you know, moving someone up, as Greg said, because they've hit a number of years of service. We are filling an open role. If there's any argument that can be made that you're doing that, I'd err on the side of posting it and making sure people know about it, because my concern is you've got a new law. We're going to have plaintiffs' attorneys looking for opportunities to address this if they have a client who, you know, maybe for other reasons felt that they were experiencing discrimination or harassment. This is one more thing that they may be testing the waters on, especially in these, you know, early years of the law. Why don't we go ahead and advance the slide one more? And so I think on this one, and after this I'm going to turn it over to Deborah, but the other difficult question that comes up here is, when do you have to comply with this law? We have multi-state employers. Some may be based in Colorado. Some may be based elsewhere but have Colorado employees. And, you know, in this case, if you're hiring someone who could work in Denver or maybe Iowa, you have to comply. And the answer in this situation is yes, you do, because the location includes Denver, at least or Colorado, at least as a possibility. And if that's the case, if you either are including Colorado or you have no location specified, and you're just posting on Indeed, hey, we can have someone work anywhere. We don't care where they sit. My view is you ought to comply with the law, because you may get a Colorado applicant, a Colorado-based applicant who ends up working in Colorado, or you may have folks in Colorado who see this, and it's a promotional opportunity for them because it could be anywhere. And so they say, you know, look, this is a promotional opportunity for me. It's really only if the job, if it's going to be performed wholly outside of Colorado, or you're advertising only outside of Colorado, that you're really, that's outside of the jurisdiction of the Colorado courts. So that's the final rules did simplify that piece of things. Do I believe everything is completely set in stone on that? The answer is no, because I think folks are going to find ways to try to challenge that piece as well. Excuse me, in response to a question of whether you have to interview employees who don't meet the qualification requirements, the answer is no. You don't. You don't have to. You don't have to interview anyone who applies if they don't meet the qualifications, but you have to let everyone know. And someone else asked if you could post stuff on a Slack channel. I'm going to admit my ignorance here. I'm not even sure exactly what a Slack channel is. I don't think I've ever used one, but if it's something that your employees regularly access and you use to communicate with them, then I would think that would be okay. If it's not something that everyone has access to and uses, then I wouldn't. So before I turn it over to Deborah, Greg, any other comments on those issues? I know that the out-of-state issue is a touchy subject as well.
Yeah, and it's rare, at least in my company, that we know that a position will be only in one location. You know, we have multiple locations, including Colorado, Massachusetts, Kansas, Milwaukee, Connecticut, Arizona. When we post the positions, we are open to having the position be in any one of those locations, including Colorado. And for economies of scale and efficiencies with the talent acquisition team, they want to have a one-size-fits-all approach. And because this is the This Colorado's setting the bar, right? That's driving this conduct throughout our postings, and we're just going to adopt this methodology no matter where the posting is, because it's just easier to do it that way. Once we've settled into the groove, that's how they prefer to do it. I think we need your
all right. Yes, I figured out the mute on my slide.
Sorry about that. I just wanted to hit one other question before I turn this over. There was a question about how long an internal, external position had to be posted for an inline promotion. Assuming it does need to be posted, I think it just needs to be posted before a decision is made. I don't believe that there's any specific requirement on how long you have to keep it posted. The important part is you're giving people notice so that they have an opportunity to apply and be part of the process. And so the concern I would have is if you're already pretty far down the selection process and you have a candidate in mind by the time you post, and then you post it, and then the next day you select your candidate, I'd be worried about that process being challenged. So with that, let me go ahead and turn it over to Deborah.
Thanks, Mark. Luke, can you advance the slide, please? Okay, so this is the next section of what you might see in a job posting. We didn't give you a sample because it would fit up the entire slide, but qualifications and the job description. So the Act hasn't changed what you necessarily need to post regarding qualifications or descriptions, but it does bring up an issue about disparate pay. So what happens if you've got very similar job descriptions for different positions and employees in one position are paid more? So with this new Colorado Act, you have to explain that pay disparity based on specified factors in the statute. And so those are seniority or merit. Maybe one employee's just been there longer, or employees in that position generally have been at the company longer. Maybe they have better quality or better quantity of production. Maybe they work in a different geographical location, so pay differences make sense. Maybe some employees travel, some don't. And then the last factor is that maybe employees in one position have different education, training, or experience. The caveat here, though, is that that different experience has to be reasonably related to the work in question. And these are the only reasons that you can have pay disparity between the two positions. So this is different than the federal rule. The federal law says that as long as you can explain it and it's not based on sex, you're fine. It's a catch-all provision. We don't have that catch-all provision in Colorado. So practically speaking, make sure you're reviewing those job descriptions. And if they're similar for multiple positions, this is the time to check and see whether employees in those positions are paid the same. Luke, will you go to the next slide? All right. So next up, compensation and benefits. So in this sample, we've said that compensation benefits are subject to negotiation. So in the past, this has been fine. This is no longer fine. In a posting, now we have to post the compensation or a range along with a general description of benefits and other compensation that will be offered to the applicant. So I see there's a Q&A question saying, for salary posting requirements, is it okay to just say that a job pays from X, or do we have to post a range with lower and upper amounts? The answer is, unfortunately, the latter. You have to post the range. Now, this could be a range from what you're paying the lowest ranked employee in the position to the highest ranked employee in the position. as long as you think in good faith that you might pay the candidate somewhere in that range. But you have to be as specific as you can. So same issue here, pay is variable, not going to be specific enough. I mean, variable based on what? It doesn't really mean anything. So, and then is somebody else going?
I was just going to add to that. If you know exactly how much the pay is going to be, I think you can say that the concern is that in most cases, people don't know exactly what the pay is going to be because, as Deborah said, it usually is a range. You're usually going to go above or below that amount. And so I think almost everyone I've spoken to about this is defaulting to a range for that very reason, even though you can go above or below. But if you put in a specific amount and then you go above or below, that's going to look very funny.
Absolutely. I've got questions about whether you can just post that it's an hourly position or an exempt position. And again, it's not going to be specific enough. That range is really what you need. And you have to be specific on commissions and bonuses. The law is pretty clear that you have to give a description of any other form of compensation that you're offering from the job. This includes even things like sick leave, parental leave, and PTO. You don't have to talk about minor perks, but you do have to talk about, at least generally, healthcare benefits, retirement benefits. So if it turns out, now that we have to post the compensation range, if it turns out that compensation range is higher than what current employees are making, be prepared to hear about it. Now that compensation is going to be more out in the open, there's just going to be more talking, more employees engaging in concerted activity, and you can't stop that. So, Greg, I'm curious, in your role, have you come across employees talking more about wages or training managers on how to handle those types of issues?
Well, we haven't had it happen yet because, of course, the postings haven't occurred. But, of course, it's, everybody's afraid, a parade of horribles. Managers are aghast that this is going to be out there, and they're freaking out, frankly, about what to do. They're expecting day one, the first time they have a job posting, that everybody in their department is going to come banging on their door asking about what about me and why is my salary different. We'll get to the slide on the pay equity audit later, but we did an audit in part because we anticipated that we, one, wanted to gain the protections of the audit under the law, but two, we wanted to really assess where we are and make some corrections within these departments ahead of time and get ahead of it, get ahead of the curve as best we could, knowing that there are some departments, just through the passage of time, where some inequities had built up. And so that was our first approach, is let's try to address some of these things ahead of time so there may be fewer squeaky wheels who are pissed off about the pay range that they just saw in a posting for a position that is junior to them or equal to them, but the pay range or salary seems to be higher than what they are getting paid. Ultimately, it comes down also to talking to the talent acquisition folks and the managers about how to address those situations. And frankly, what we've said is the managers should not necessarily address those questions without help from HR and legal, frankly, behind the scenes. Because in any situation where an employee is complaining, we're going to take it as a gift, right? It's an opportunity for us to evaluate the situation and maybe get ahead of the curve before something lingers too far. And the employee becomes too disgruntled and then files a claim. We want to use it as an opportunity to find out if there is truly an issue. So what we have is essentially an agreed upon path that if an employee raises those concerns, the manager notifies HR, HR notifies us. We would work with the compensation team, to really do a quick and dirty analysis of that group. And if there's an opportunity for adjustments, then we'll try to do so. And we know this is going to be a painful process for the next year at least, as some of these things get worked out.
Absolutely. Luke, can you go to the next slide, please? So there is good news. There are certain exceptions to these job posting requirements, but they're very limited. So the first one is for an incumbent. So this could be if you're planning on replacing somebody who's still in that role, but for certain reasons, you don't want to notify that person that they're about to be replaced. You could be worried about trade secrets issues, them taking company property, whatever it is, but you want to keep it confidential that you're posting to replace that person. There's another exception for temporary employees. So you don't have to do a promotion to fill a temporary position if you know that it's only going to be about 6 months. And then the last one is automatic promotion after a trial period. So Mark touched on this briefly. So you don't have to do another posting if the employee is automatically promoted. So maybe they finish their probationary period. As long as you've got written representation in an offer letter, employment agreement, or a policy saying that you're going to automatically consider that person. All right, Luke, can we go to the next slide, please? So let's talk about the next stage. After you've done the job posting, the interview. And can we pull up the next polling question, please? Perfect. So while you guys are answering that, I'll just keep on chatting. So we leave plenty of time for Brenda. But the big thing now that the Equal Pay Act has changed is that you cannot rely on past wage history when you're setting an employee's salary. So this means in the interview, you can't ask about past wage history. If somebody tells you their past history, you can't rely on it in making a salary decision. And if somebody refuses to talk about their past wage history, you can't retaliate against them. All right, can we close the poll and release the results, please? All right, so at least some people planning to do training, this is good because this is where companies are going to start potentially getting into trouble, asking questions that they shouldn't because the rules have changed. The next issue on salary negotiations is what if somebody wants a salary higher than the compensation range that you posted? Are you allowed to pay them that amount? The answer is yes, as long as that posting was made in good faith. Can we go to the next slide, please? Pay audits. All right, we're just going to touch on this briefly, but the big thing about a pay audit, which essentially measures where pay disparities are in the workplace, is that it's good for morale, and it's also good legally speaking. So good for morale to correct issues before you get sued. But from a legal perspective as well, there are very heavy damages under the Act. So this could be up to 3 years in back pay, up to $10,000 if you have a posting issue, attorney's fees, and they double the economic damages with liquidated damages. But if you've done a pay audit in the last 2 years before the lawsuit, you can show good faith, which means you may not have to pay those doubled liquidated damages. So our recommendation here is to do a pay audit every 2 years. And if you see issues in those inline promotions in how people are getting raises or bonuses, make sure you're taking action based on the results. And with that, let's go to the next slide, please. And I'm turning it back over to Mark.
All right. Thanks, Deborah. Really helpful. So I'll touch on this briefly so we can make sure to get to Brenda's stuff. But this is a really good opportunity to review your offer letters and employment agreements and make sure that if they reference PTO or vacation, that your policies are in compliance with the new paid sick leave rules. We'll be addressing those in our next iterations of this series, and those dates are all in the invitation that was sent out, or you could find them on our website. But it's also good to talk about at-will disclaimer. That's just one of those things that should always be there. Making sure that your exempt, non-exempt classifications are appropriate if you've got that information in there. And just because I've litigated a number of these issues, I always like to put a plug in for an integration clause or something that says, hey, this is it. You're not relying on any any promises outside of this letter, or there's going to be a full agreement that's going to address these issues. We could advance to the next slide. Okay, so here's how I feel when 409A comes up. This is my reaction, and this is why I call Brenda to help me out. So with that, Brenda, I'm going to turn it over to you.
Thanks, Mark. Yeah, I either get that on 409A or I get it when I say I'm an ERISA attorney. So either way, I get that reaction. But 409A, if you don't know, is a code section, tax code section that can really easily impose an extra 20% tax on anything that's considered deferred compensation. We wouldn't think usually of deferred compensation in employment agreements and offer letters, but it sneaks in there in some sneaky ways. And so we thought, since Deborah and Mark and Greg are covering and have been talking about some of the red flags that you have in the rest of the hiring process in this phase of the employment cycle, this would be a good time to just take a few minutes to do a quick refresher on that. So let's go to the next slide, please, Luke. I'm going to go pretty quickly on these slides, and then we're going to look at an actual offer letter. So your question, deferred compensation, when 409A only applies if it's deferred compensation. If 409A does apply, then you have to meet these really strict timing rules. You have very little flexibility on changing things going forward, and it's not that hard to comply with. The biggest thing is, if you don't comply, yeah, this huge penalty tax, and you end up having taxes, up to 75%. So you have your regular taxes plus an extra 20% tax plus an interest penalty. And so the consequences are really disastrous, even though it's not necessarily that hard to comply. Also, like I said, you have a very limited ability to change things once they're considered 409A subject to deferred compensation. So, I know you're probably know about this. Like I said, it's been around for 15 years. You probably aren't experts on it if you're drafting to your employment lawyers, and that's totally fine, because really what we're just trying to do is kind of highlight some of the issues so that you have some familiarity, just to know to think about it if you see the red flag. So go to the next slide, please, Luke. Okay, so there's a couple really big exceptions that help us in the employment context stay out of 409A. And this one, you probably already have the language in your agreements, but basically it's sort of the vest and pay rule. If it's paid shortly after vesting, and then you're going to be okay. It's called the short-term deferral exception. You've got a couple exceptions to 409A that we're going to talk about here that takes you out of 409A and gives you a lot more flexibility. I see a lot more, but not total flexibility, because even if something is under there, you still, every time you're going to change the timing, we get the executives that then later they have it in their employment agreement and say, well, actually, I want to receive it in 2 years instead, or something like that. That is always a problem, or always something we need to work through, because, like I said, even though it's been around for a really long time, 409A is very complex and hard to fix things if it's screwed up. But basically, if you pay it within 2.5 months after the end of the year in which it vests, then you're going to be in the short-term deferral exception. You can use the fiscal year for the company sometimes. But if it could be later, then you don't meet this exception. Okay, next slide, Luke. And this is kind of what is vesting. Vesting is whether there's a substantial risk of forfeiture. So I'm not going to go through the detail on this because I want to get to the offer letter, but we are sending the slides out after this, and you'll have that sort of short version reference. Okay, next one. And there's also, important to know, separation pay exception. Now, when we're on the other end of the life cycle, we'll probably talk a little bit more about this, but basically, if you're getting separation pay for involuntary termination of employment, and it doesn't exceed more than 2 times your salary and not more than up until the end of the second year following, you can usually fall into this separation pay exception, so it gives you a lot more flexibility. Okay, now let's move on. I know this is hard to see, but I wanted to use a real agreement. This is Mark's agreement, draft agreement. Now, we actually took it and then I crammed in a bunch of problems. So this is way more problems than we would ever see in a normal agreement. But if you let's start skimming it, please offer the basic position and summary of duties. Obviously, you need to consider all the other things that they've been talking about when you're talking about your position and summary of duties. And by the way, it will be, this will be easier to read when you get the slides coming out to you later. So I'll just kind of read some of it to you right now in case any of you are having eye issues with age like me. Your start date, this is just kind of basic. We kind of cut these things out. You have your salary in there. And then we get to the one that is really the common one, short-term incentive bonus. You'll be eligible for our short-term bonus program. Company will pay you an annual bonus of X% of your base salary with successful measure of hitting individual and company goals established prior to the beginning of each calendar year or within 30 days of your employment for the first year. Sounds pretty good. What's wrong with that? And Greg, you could feel free to jump in too if you want any of these, but I'm going to pretty quickly just sort of say these again are just red flags of things to watch out for every time you're doing it. We're not going to be able to work through all of the possible analysis on it. What's wrong with it is we don't know. First of all, we assume it's paid in a lump sum, but that's an assumption. You could specify that. But the big one is, when is it paid? So is it paid after the end of the calendar year? Is it paid within a number of days that would always comply with short-term deferral, or do you need to put in there paid no later than March 15th of the year following the year for which the bonus was accrued? Something like that. And then the other thing, what happens if they terminate? If it says that they're going to get the bonus anyway, let's say it's based upon company performance, for example, if you're going to get the bonus anyway, even though they terminate in February and they get the bonus next March, now you've got deferred compensation because it vested at the minute that, or it could be deferred compensation. So there are exceptions where you can still be considered subject to a substantial risk of forfeiture, for involuntary termination and some other things, but those are what we want to be specific about in there so that we make sure we don't have a violation. The next one, I'll just quickly, the benefits issues. These we do not see that often, but sometimes, and I cram, like I said, a bunch in here. You'll be eligible for 100% employer-paid health insurance coverage as well as other benefits. People try to do that for their top people, right? Well, if you have a self-insured health plan, that is a no-no to do something different for your top people, for the big kahuna versus the other people. So the best thing to do, and the next ones are too, you'll be immediately eligible to participate in our 401k plan. That might be true, but a lot of times the people writing the offer letters don't really know the terms of the 401k plan. In the same thing there, which matches 100% of your contributions up to 6%. So they maybe do know those kind of basics, and maybe you do have to reveal that in your postings, not to that level of detail. But the point being, it's best just to say you're eligible for our 401k plan and health insurance plan under the terms of those plans and other benefits under the terms of those plans, and not do something special. That's usually the best thing to do. Again, they can't do a special profit sharing contribution for them. It references there. Can't do special service crediting. We do get that question quite a bit. We want 100% of that, or I shouldn't say quite a bit, but sometimes, that they want to 100% vest somebody immediately because they're leaving their other job and they don't want to be subject to the 5-year vesting schedule that everybody else is. You might be able to do it in a non-qualified plan, but not in your qualified plan usually. So those were kind of the problems on that page. Moving on to the next page, Luke, please. Equity, it lists here, they're going to get equity at a strike price of $30 per share. We don't see this problem that much anymore, but boy, when 409A came out, people hated this. We can't, you cannot go below fair market value, and there's rules about how you have to determine fair market value at the time it is issued. Otherwise, it's deferred compensation, and you do not want your stock options to be deferred compensation. So that's just, again, easy fix. So that's kind of the overall theme here. These a lot of times are easy fixes, but they still sneak in here. Moving expenses, I just wanted to highlight here, it says we're going to reimburse you on a non-taxable basis. That's not allowed anymore. That law changed last year. It's all taxable now. So just mentioning that, you usually probably wouldn't put the taxation in there. Anyway, severance. Like I said, we're going to go over that much more detail in the other thing, or hopefully if we have time in the other one. Or by the way, if there's interest in these 409A topics, we're just kind of hitting them extremely high level here. If there is interest, we can always do a separate webinar on them. Here we've got, again, promises of what they'll be paid for severance. And that almost always needs to be evaluated to determine if it's a short-term deferral, if it's under the separation pay exception, or if it needs to comply. So I don't have the time to go into any of the detail on whether those comply, but you can see it when you get the slides, basically the first one well, I guess we already passed 1 o'clock, so I better cut it off. So sorry about that. But anyway, those are just, whenever you have severance, you do need to consider that as well, if you're putting it in your agreement.
Brenda, what this has highlighted for me is I definitely needed an in-depth refresher on 409A because my head is hurting looking at this and thinking about this. And now I'm second guessing, what some of our high-level officer or, high-level people offer letters say. I frankly have always thought about it from the context of the separation agreement and making sure that we structured that if it's, some sort of performance related and the timing of it, but honestly, I've never thought about it from the beginning of the life cycle, the offer letter, and now I'm sweating a little bit.
Sorry. I know, maybe it won't feel so bad when we go slower grade, maybe it won't feel so bad and it'll all make sense and all of your letters are probably fine. Yeah, and like I said, I also crammed so much into this, it's highly unlikely that we would see so many problems in one. Although I do think when you read through this, I think that to an average person, this would read fine. Nothing would stand out as being a problem. It's written very like a normal letter. So I think that is it's common for the other party to come back with, no, this is what I want, and then they make the changes, which might completely flip you into a different analysis.
Yeah, I agree. Thank you.
Yeah, thank you, Brenda, and thank you, Deborah, and thank you, Greg, for all of your helpful insights, and thanks to everyone for participating today. We really appreciate all of your really good questions, and we certainly hope this was helpful for everyone, and we hope you're able to attend the upcoming webinars in this series, and hopefully they'll help everyone deal with these thorny issues throughout the employment life cycle. So thanks, everyone, and hope everyone enjoys the holidays and stays safe.